we have a few of us who are having challenges. So we are going to, I would want to really address some of the issues that we may be facing. But maybe just 2 people to give us their feedback on how they are faring. And maybe Kirinya, Caroline, you can tell us how you faring, how is the safari? Okay. So, Kenywa, karibu.
Asante.
Share with us your experience in the safari.
Very enjoyable.
Okay. Where are you? What challenges are you facing? What have you learned in Unit 3 and 4?
The challenges are the internet fluctuation. Here in the office, the internet is not very stable.
Okay.
But we are coping with it. I've learned a lot, in fact, so many things. Because I've known the rights of the data subject, the obligation of the data processor and the data controller, and the establishment of a data protection officer. Learned about all the legal matters about data protection.
Okay. Okay. Thank you so much. Thank you so much. Collins, with us your experience.
Good afternoon, everyone. My experience is very nice. I'm learning a lot. Yes, there's balancing between going through the course and working is quite a challenge. Given these 2 weeks that we are having, there are other activities within the institution that require my attention and also a lot of travel, so it's been a bit difficult. But I believe so far so good. I've been able to achieve over 50% as of now, and I believe that with the small challenges here and there, we will still surmount and be able to go through it. Yes.
Okay, thank you so much. I want at this time, so that we have time also to interact with the facilitator, I want to welcome our Deputy Director who is with us to say hi to us, and also to welcome Brenda, who is taking us through this afternoon session. Over to you, Vera.
Good afternoon, Nathan. Good afternoon, Brenda, and good afternoon, all the participants. Sorry, I'm in a place that may not allow me to turn on my camera, but I have just stepped out. But thank you very much for joining today's meeting, today's webinar. We are very privileged to have Madam Brenda with us. I think you have seen her introductory video about what she does. She's a lawyer, an advocate of the High Court, and therefore very well equipped to take us through this session. But beyond that, we are very happy with the progress that has been done by many of you on the platform. We are moving and progressing well. Of course, we'll always have people who are way ahead of the others and some who are a little behind. Mr. Kinywa, thank you for raising those challenges and even the rest, because those are the normal challenges we go through when we are going through an online program, especially in the context of Africa. When you're working full-time and you have to balance your work, like has been said, and then you need to find out where can you get internet, is it at home, is it at work? And then so those are some of the should I say, the concerns that are there, not only in Kenya, but even worldwide for all programs. So even as we do that, the reason why we are really working and why Nathan keeps saying leave no one behind is because as much as you face those challenges, our motto or our real determination is to make sure that we all complete the course regardless of where we are. And even the challenges that you're facing, we try to see how can we help you to be able to mitigate or just to be able to make the journey a little better. So we are grateful for each of you and the efforts that you've made. We'll continue to work with you the rest of the journey. And even now, as we look at Unit 3 and Unit 4, I believe we were able to do the regulatory and the introduction very well, and we now have a very good background. So today, as we delve in even to looking at the rights of the data subjects, and we look at the other topics that you're going to be able to very well participate very well because you have been able to go through the content, and therefore, as Brenda just summarizes and provides the highlights, it will then be able to help us to raise out the issues that we have and also be able to ask for clarifications in the areas where we are not very clear. But at the same time, it gives us an opportunity to engage with each other and to engage with our facilitator and to also just learn from one another even as we meet during this webinar. So I want to thank you all for attending. I will be with you until the end. I just may be a bit quiet, but all the same, I always like attending the webinars because I always learn something new as well. So thank you very much. I want to welcome Brenda to take over the session as she runs us through Unit 3 and Unit 4. Thank you very much.
Thank you so much, Nathan. Thank you so much, Madam Vera, for the warm introduction and the welcome. I'm so glad to be taking you through these key highlights. I don't know if you can see me. Somebody to confirm.
Yes, very lovely.
Can you hear me?
We can see you, we can hear you.
Oh, good, great. I hope where I am there is enough light so that I'm not dark. So thank you so much. I've been able to see how many participants we have. I've been able to follow the interaction, and Karanja was kind enough to share with me some questions that were some of the questions you raised during your interaction with Unit 3 and Unit 4. So I will endeavor to do the key highlights and then at least have a few minutes to answer the questions that I have. And then we can also have a few minutes to interact, maybe verbally, where you can just unmute and ask your questions. Allow me as I start to turn off my mic. At least you've been able to see me. Can be able to put the face and the name together, and I'm sure we've interacted on the video online. Okay, because of time, I don't want to take so much on the preliminaries. I just want to go straight into the key highlights of Unit 3. You've talked about the rights of data subjects, and many of us have expressed that we have learned so much about the data protection law and the framework, and now we have come to realize that under this framework there are also rights. And maybe as a first point to start off, I would like somebody to just tell me, from your understanding and interaction, what do you understand by a data subject, or who is a data subject? Somebody can just unmute and say, so that I can be sure that we've all understood who is a data subject. You can also choose to mention, you can choose to tell me who is a data subject, or you can give an example of a data subject according to what you understood. Anyone before I choose, because of time? I can see Gary G, kindly, who is a data subject according to how you understood it.
I think a data subject is a person whose data is being processed or being accessed by the entity that is doing so.
Okay, great. A data subject is somebody who is the subject of data that has been collected about them. And I'm sure by now we are very clear on what kind of data we are dealing with, personal data, right? Christine, give me an example of a data subject.
Hello.
Yes, we can hear you.
Yeah, an example of a data subject is a patient to a hospital. Give you an example of myself.
Oh, great. Thanks. At least with those two answers, I'm able to gauge that each one of us has some rough understanding of who is a data subject, and why I'm very keen on finding out if you have gotten that concept is because the subject of Unit 3, or the subject of the rights of under the law or under the data protection is data subject, and a data subject is anybody who you have collected data, including yourself. If you have ever shared your data with any entity or any person, you become a data subject. One of the key distinction is people don't realize that their customers, their clients, their suppliers, their employees, their even with NPS or the police, if somebody gives you their data, records a statement, all those are data subjects. So this afternoon, we're just going to highlight some of the key things that I'm sure you have already gotten grasp of. One of the key highlights I would like to start with is these rights are only accorded to data subject. That means we exclude those things that we talked about in unit 1, where we say that companies, legal persons like companies, robots, are not data subjects. So you cannot seek to protect the personal data of a company. You cannot seek to accord a company privacy rights, as many people have always confused this law with. So the rights under the data subject are only accorded to data subject, which includes all what we've said, and yourself. Never forget that you're also a data subject. One of the things I would like to always say, that whenever there is a right, definitely there are some limitations. All rights are equal to all persons under the law, under the Constitution of Kenya. However, we have some few limitations, which I just want to enumerate this afternoon. Not all these rights you're going to find that are going to be absolute or are going to apply absolutely. The first right, which is an absolute right, which you cannot deny anybody, is the right to access their personal data. Somebody needs to have unfettered access to their personal data, because this allows a person to be able to enforce all other rights. So this is the only right that is absolute and cannot be denied. Now, the law has not been very clear on how to allow access, because it is left to innovation, it's left to practices, it is left to organizational measures and safeguards. So you need, as an organization or as a data subject, to understand that the person you're seeking to enforce your data protection right of access will differ from time to time, and that is because it is not wired in the law of how you should be granted access. The law, the principle is clear that access should be granted to a data subject. Some of the examples you have realized from time to time is access on your eCitizen platform. You usually have an account and you're able to access at any time, anywhere, so long as you have some smart access or some internet, you're able to access. Now you go to another place like a bank or an institution, they may allow you access maybe via copies. They do hard copies for you, they allow you access. Other places they may allow you access by you going, giving your details, and then the person will tell you the details you would like to know by word of mouth, orally. So there are different forms of access. However, the bottom line is always allow somebody to access their personal data, and questions arise on HR files, personal files. Can I be allowed to access my personal file from HR? And the practice has always been allow the person to access the data they gave you, at least as the bare minimum, because if many people have argued that this information has been collected by the organization from time to time about you, and it may be sensitive, it may include other people's information. So all this can be taken into consideration. Otherwise, always allow the person to access their personal data. Quickly on, the first right is the right to be informed. Always inform a data subject of they have the right to be informed of how you're going to use their data. Now, this has not been a very common practice, especially I'm sure every one of us has experienced going into a building and you're just told, bring your ID, write here, sign here, and you give so much detail so that you can be allowed to enter into a building. No one, I don't think anyone has ever been told, hey, welcome to KICC. We would love to ensure that you're secure and the place is secure for you. Please furnish me with your ID. I will be able to take this ID and record the following details. And after that, I'll give you your ID upon exit of the building. You're telling the data subject exactly what you're going to do with their data. And maybe finally you tell them that I will keep this data for maybe 7 days and I will destroy it, or I will shred this book. The law is anticipatory that everybody should be well informed of how their data is going to be used. So many people have come up with ways of doing this is by having privacy policies. Many websites right now, if you go to a website, you click, you will find you being asked about your privacy. I'm also seeing here this session is being recorded. I can see a privacy policy popping up on my device, just allowing me to make the choice about my privacy and informing me of how my data will be used. So that is simply some examples of how you can better inform the data subject of their right to be informed. Now, when it comes to these other rights, the right to restriction, the right to access to deletion of false or misleading data about somebody, all of these rights are accorded to a data subject. However, these rights have limitation. You will realize from what you have learned is that sometimes there are claims that supersede your right. Maybe the controller or processor will have a legitimate interest, or they may have a statutory obligation, like many of you in this forum. Some of you are coming from government, and there are some obligations that are accorded to you by your mandate and from the law. So you'll find that there are some things you're not able to do. For example, the DCI, if they're investigating someone, they would not come and ask you for your consent to continue or to investigate you. or to access your personal data. That is because it will jeopardize their work. So you'll find that all these other rights have certain limitations, which I'm sure you've been able to interact with. So you will find that there has to be a balance. And that question which you were asked initially, if you're a doctor and you have a patient, and this patient is in a state where they cannot give their consent, and you have to save their life, I'm sure all doctors know that the primary thing to do is to first save the life and then think about all other things. And that's the kind of balance you'll always be asked to strike whenever you're faced with a situation where it is somebody has asked to enforce their right. However, once you weigh, you lean more towards not enforcing their right. And there are some obligations that you have to do. If you do not enforce somebody's right, you must inform them in writing. It always has a time stipulation, so be very keen about the timing. Some are 7 days, some are 14 days, and you must give them reasons of why you have not enforced their right. A good example that is going on is what the Ministry of Interior is doing with the Department of Immigration. People have complained about the delay of issuance of their passports. So sometimes I have applied as a data subject. I'm waiting for my passport. Some are saying it's been 1 year. So what the Department of Immigration should have done is to ensure that they progress within the shortest time possible. And if there is a delay, they need to inform the data subject in writing. Or if they may not proceed with a certain application because of maybe the documents given are not sufficient, or there are some documents they need to give, the department should have informed the citizens that according to your application, we are denying you. We may require you to, furnish us with X documents so that we can proceed. But keeping quiet and taking all that time, for sure, is in grave violation of data protection rights of a data subject. And the good thing with these civil registration entities, they are also governed by the Data Protection Act, and they have the civil registration regulations, which are guiding them of all these rights that we are talking about. So I will not delve into each of the rights because I've just given the key highlights of what each right should entail. Should there be a denial, you must inform somebody. Should there be a reason why you may not comply with one of the rights, you need to inform the data subject within the shortest time possible. Most of the time stipulation are included in the regulation, so you can always make reference to them so that you can not be in violation of the rights of the data subjects. Another key thing you'll realize is the rights of children. Children are very important when it comes to data protection because they are minors and also vulnerable people, vulnerable groups. This may be people who are not able to form consent. Therefore, they'll need somebody else to act on their behalf. These are also covered in the data protection framework, such that there are some parameters which are needed for you to enforce the right of somebody who is not able to form consent on their own. So as organizations, you need to be very key, and almost all organizations process personal data belonging to children. And if you think you do not, just ask yourself, when we are collecting our employee data, do we ask for beneficiary details, the beneficiary details? If you do, that means you're in the bracket where you collect personal data belonging to children. You must ensure that you assure yourself of the best interest of the data subject if somebody is acting on their behalf, and that includes the children that I'm talking about, you must have come across the question which asked you, now that you have learned about the Data Protection Act, how do you see yourself handling personal data belonging to children? As an organization, what can you do going forward on how you treat personal data belonging to children? And I'm sure many of you have relooked and seen the different practices you have when it comes to personal data belonging to children. Or even yourself, if you're a parent and you're dealing with a school, how are the schools dealing with the personal data of your child? How are you yourself dealing with the personal data of your child? And not to say that even us as parents, we are data controllers and data processors. I'm just trying to tell you that if you put information out there of your child, maybe you broadcast your child on one of the social media platforms, and you put their details and their school details. Many times we've been found unawares, pictures of children are on billboards, in a bid to advertise, or you find yourself um, sharing photos, sharing videos. You must be very keen going forward, because all that, a child is taken as a data subject, and you must get the consent of their legal guardian before you can do all that. So you need to think about these things very critically when it comes to processing personal data of children or any vulnerable group. Maybe I can pause here and ask, give me an example of somebody you think is vulnerable, who is not able to form consent on their own, such that somebody else has to act on their behalf. And one of the examples is children. Just give me another one so that I can explain something. I'm seeing Mr. Ngetich, if you can answer that for me. Mr. Ngetich, are you with us? Okay, anyone can unmute and answer. Give me an example of a vulnerable person who is not able to form consent.
A person who is mentally incapacitated.
Yes, perfect. A person who is mentally incapacitated, a person who is unconscious. Many people are saying, oh, the elderly. It's a 50-50. If the elderly is able to form consent, like during the elections, or when they are doing the registration for voters, are you allowed to sign on their behalf if somebody is so old? No, everybody is able to enforce their data protection rights unless otherwise somebody is completely incapacitated and unable to. And some of the very new rights that maybe even you have come across right now, which you're thinking as an organization or as a person, how are we going to deal with this? Is the right to erasure or the right to be forgotten? I don't know what you thought about such a right. It's somebody asking you to completely forget them, completely delete them from their system, from your system. It's not as complicated as it sounds, but sometimes it can present some challenges when somebody asks you to forget. A very clear example is if I was working with your organization and I've since left your organization, and maybe I was in your database, there's no need for you to keep my records if there's no justification for you to keep my records. Sometimes you may be asked to forget or delete that person's records. So you need to inform yourself of how long do we keep personal data? Do we have records of maybe interns who are coming just for 3 months? And then how long do we keep their records? Somebody can choose forget I ever existed in your systems. You need to be able to do that. The only limitation is there a reason why you may not be able to delete somebody from your system? Then you need to give reason. Some of the reasons are you have a contractual obligation, it's a legal or statutory obligation, it's very impracticable to do so. But if not, you are required to honor that request. Another request that goes hand in hand is the request to object. Somebody can object you to using their personal data. For example, many of us have been victims of supermarkets sending us, or not only supermarkets, people who are in sales and business sending us promotional messages. I can object to you using my personal data because from the beginning and the inception of the unit, you realize that we cannot escape our data from being all over and everywhere. So we just have to find a way of holding those with our data responsible. So you can find that you shopped somewhere. Like recently, I buy pizza from a certain place. So they called me just a few weeks ago to ask me to tell me about their offer. I wasn't in the mood of a pizza, but they just thought they should call me to remind me. So if I'm uncomfortable with such calls or such messages, SMSs, I can simply tell the place that, please, I am shopping with you, but I don't need any future messages. I don't need any promotional messages. I will come to you when I come to you. So you have that right. You have the right to tell Naivas, you have the right to tell Tuskys, Carrefour that, hey, it's okay, I do shop with you, but you do not have to send me messages from time to time. And some of you will find that it doesn't bother you, but there are those who it bothers. So you do have the right under the Data Protection Act to ask for that. As I said, all these other rights have limitations and they must be enforced in balance with the right of others. And you will see this when you're doing the exemptions and the considerations. Sometimes when you're trying to enforce your right as a data subject, you realize that it's not possible because other people also have rights. So you may not be able to completely enjoy the rights. A good example is during the COVID times. We were required to share our status. Maybe if I was found, maybe I tested positive for COVID, I would have to come to work and tell our HR so that they can know and inform the rest of the colleagues that not to come into contact, or I will have to share my contact details so that they can do the contact tracing to be able to curb, the greater harm that would have been occasioned if in at all they try to respect your right to privacy. So sometimes you realize that it's not a very clear-cut thing to enforce, but as far as is possible, as far as nothing prevents you, ensure that you enforce the rights of a data subject, or you as a data subject ensure that you are accorded the privacy that has been accorded to you under the data protection law. I don't know if there are any questions up to there. Are there any questions? I can get questions from the floor before I delve into Unit 4. If there's anything you need to be clarified. Any question? Should I proceed? I need at least one person to give me the go-ahead that I can proceed. I'm also trying to confirm that I did not fall off the call. Can I be heard?
Yes, you can proceed.
Oh, thank you so much. So we proceed to Unit 4. Now, you do realize that for every right, there exists an obligation on somebody. So if I have the right to access, that means there's somebody somewhere who has an obligation to ensure that my right to access has been enforced. And this is where now many of you come in, and many of you have been sent by your organization to come and learn and try to see, yes, there's this new law, the Data Protection Act. How are we going to, deal with it? How are we going to make ourselves ready? So you remember the quote, every right implies a responsibility, every opportunity an obligation, every possession a duty. Now, the key player in Unit 3 is the data subject. Okay. Now, the key players in Unit 4, the obligation, is the data controller and the data processor. Again, I'm going to ask one of you. I can see John. What do you understand? Give me your understanding of a data controller. John, can you hear us? You can just unmute. Okay, I can see Ryan. Ryan, do you care to explain to us what do you understand as a of who is a data controller? Okay, I'm beginning to think I'm falling off the call slowly by slowly. Can anyone hear me?
Yeah.
Okay, perfect.
Yeah, we can hear you.
Yes, please, what do you understand who is a data controller?
A data controller is a natural person or a legal one that determines the purpose and means of processing personal data.
Oh, perfect. Thank you, Paris. I need now the boy child also to be represented. Who is a data processor? One of the gentlemen meant to, to represent the boy child. Who is a data processor? Anyone? Okay, thank you for the one who has raised the hand. Please go ahead and speak. Go ahead.
So let me go. A data processor is a person or a company or any other body that processes personal data on behalf of data controller.
Okay, now give me an example. It was Timothy, right? Give me an example of a data processor. Any example of a data processor you know? Because we must bring it home. We need to understand in our context or in your context where you are from going through this unit, who would you understand? Like, give me a practical example. Who is a data processor? Okay, I'm seeing some.
Maybe I can explain it on the context of where I come from.
Yes.
Whereby we give cloud services to our customers. So for that case, we are a data processor whom we are handling that data on behalf of the customers.
Okay, good. Thank you, Timothy. You see, you know the answers. Paris, give me an example of a data controller.
I think an example of a data controller is maybe an employer who is taking information from personal information from the staff they want to employ or from interviewees.
Okay, perfect. Thank you so much. These are perfect examples of controllers and processors. Our day-to-day interactions with anybody who we are interacting with at the point of where we share any personal data with them for purposes of processing. In whatever scenario you're in, you'll either be a controller or a processor. You'll always be either a controller or a processor or a third party who is not very much common. There'll always be somebody who has control over the data, and there'll always be that person who is acting on behalf. So whenever you're doing anything, always think about whatever process you're doing, always think about, in this scenario, who am I? And the reason to be very clear on that is so that you can know the obligations you have under the act and and the liabilities you have. Most controllers have the liability. They take responsibility because they are the ones in charge of determining the purpose of processing data. That's why it's very good to know who is the controller. Most of our government bodies are controllers in their own right, because most of us have mandates. Okay, so we determine a lot of what we do with data, and most government bodies have outsourced some of the services. Some have outsourced the payments. Some have outsourced the HR function. Some have outsourced. Most people have insurance. Banks have outsourced some cloud services or platforms like eCitizen. To just make your work easier, you will always find that every day we have such kind of relationships. So a processor and a controller, they all have obligations under the act, and they are all supposed to abide by the principles of the Data Protection Act, which you talked about in Unit 1, the principle of lawfulness, fairness, transparency, the principle of I'm forgetting, data minimization, purpose limitation. I'm sure right now those principles are on your fingertips. So one of the key things I would like to point out, even as we are just doing key highlights and refreshers, for every right that a data subject has, ensure that you're able and you have the know-how of how to enforce that right. If a data subject has the right to be informed, ensure that as an organization, you're able to demonstrate that you have informed a data subject of their rights. If a data subject were to come to you today and say, I want to access my personal data, ensure that you have a mechanism in place of how this data subject is going to access their data. If there is any communication you need to make, ensure that you have all these steps in place to ensure that a data subject is able to enforce their personal data. Ensure that the data subjects, all the principles that were talked about are enforced. What are your organizational measures? Some examples could be what is the culture in your organization, especially with respect to privacy. Some of us share laptops, share desktops. They don't have passwords. They are not protected. Anybody can access data from nowhere, from anybody who comes in can access data. So those are some very bad practices which need to be looked at. I'm just giving examples. I'm not saying that's what happens. What are your technical measures? What technicalities have you put in place to ensure that always the privacy of anybody who you have their personal data is maintained? What are the safeguards? Have you put a biometric system? Have you ensured that I am not able to access the payslip of my colleague? I'm not able to access the personal file of my colleague if it's not within my right to access that file. Have you put in place such measures? Like I know some organizations have put in place measures such that if you're trying to put a password more than twice or 3 times, then the system blocks. The system can tell that somebody is trying to get in without access, without being very sure of the password. So it detects and can tell this may not be the owner. Those are some of the organizational or technical safeguards that you can put in place. Or requiring people to put strong password, having a password policy in your organization for maybe accessing of documents, having such things like marking of documents of whether they are confidential, who is accessing these documents. Those are all things that you're going to be obligated to put in place in order to ensure the privacy of a data subject. If a data subject comes to you and they want to rectify their personal data, are you able to do that? Are you able to ascertain that indeed this is a reasonable claim and we can go ahead and rectify because we've been able to satisfy ourselves that this data is indeed inaccurate, it's untrue, it's outdated, it's incomplete, it's misleading? Are you able to do the data portability, which, moving from one data controller to another or a data processor to another? Are you capable? Do you have a budget? Have you put things in place? Then another key obligation is notification of a data breach. Many of us, whenever we get auditors coming to audit us, we are always on our toes. We are always on jitters. Not so with data protection. Data protection requires that if something has occurred in your organization where a breach, maybe some data has been breached, for example, a laptop belonging to the finance director has been stolen, so data has been leaked to the media, you need to report that to the data commissioner within 72 hours if you're a data controller. And if you're acting on behalf of a data controller, meaning you're a processor, you need to report that within 48 hours. Now, what does a data breach notification do for you? It helps you to identify the problem. It helps you to inform the data commissioner some of the steps that you're going to take. It helps you to evaluate your systems. For example, these things that many organizations employ, hacking, testing your systems, testing to see if you have strong walls, you have strong protective measures. That's what notification of a data breach does for you. And it also helps you in terms of justification in case you're audited by the data commissioner and they find that data was breached but you never said. That's a ground for non-compliance, and you can be fined or given an administrative fine, and that can be dire for an organization. Then you must communicate to the data subjects. So you must ask yourself, how are we going to communicate a data breach? Who is going to communicate the data breach? What's the first point of call? Who do we call? So all those are obligations that require you to put in place measures. Then we have something we call recording processing activities. You need to record all your processing activities. How many of us have done a data map? Data mapping is, knowing all the data that you collect. Who are your data subject? How do you, what are your activities that you do with data? How do you deal with personal data of data subject? How long do you store it? So you must be aligned to some of these obligations. Then a key thing is something we call privacy by default or by design. You need to ensure that your systems are ready. By default, there is privacy. By design, the way you've designed your organizational measures, the way you've designed your system, by default, they are privacy oriented. Okay, such that as an employee, I'm not worried of my status being known by the whole organization, because our HR is very open when it comes to how they are keeping our data, or I don't feel my privacy is violated because I gave Google pizza. I bought a pizza once, and now my information is being shared left, right, and center. All those are things that you must align yourself to. Then a very key one is the data protection impact assessment. Very, very key, because this assessment, just like the one we have, the environmental assessment, is it tells us of what we are doing, what measures do we have in place. If we are going to carry out the maisha number, is it the maisha number now, or we are going to do the huduma number? How is it going to impact the rights or freedoms of the data subject? If I'm collecting all this data, how is it going to impact their right to privacy and their freedom with respect to data protection? So I must do a data impact assessment just to align myself, to ensure that even as I'm collecting this data to offer a critical service for the citizens of Kenya, I'm able to assure myself that this data is well protected. This data, even as much as I'm collecting it, it's my mandate, it's my duty to collect it as a government, but it is well protected. It will not in any way harm or cause harm to the data subject. Okay. Then there is the obligation of registration. Many government entities have not registered with the data commissioner. It is a requirement for us to register upon realizing that you do collect personal data, you do deal with personal data, you need to register with the data commissioner. This registration began way back in 2022, last year, from July. So there's an online platform that you can get onto and do the registration. The data protection registration regulations are available online, and they offer a step-by-step guide on how to register as a data controller or a data processor, or even both. And once you're doing the registration as a data controller and a data processor, both, you need to do separate registration, and you'll be given separate certificates for each of the categories that for the two categories that you've registered. Okay. The fees of how much you'll pay and the criteria are also in the act, in the regulation, so you will not be left to wonder what it entails for you to register. Then there is some institutional documents that you need. A data protection policy is very key, and this can include how you deal with personal data, what are the rights, how do you collect the data, who do you share it with, who are your key stakeholders, how long do you keep different data. I can keep my employee data for maybe 7 years, maybe according to an act of parliament, or I can choose to keep my employee for my data for 20 years. Maybe I've given a good justification of why I need to keep that data for how long. So this policy will include all that. And then we have something else we call the data protection, the agreements, the contracts that we will have with our data controllers, between a data controller and a data processor. The key reason for this is because as a controller, you always bear the liability and the responsibility for data. So if it is in your best interest to ensure that you have a contract with the data processor to ensure that they will protect the personal data, as much as you protect the personal data, because you will always be liable for their actions. However, there are instances where the data control processors will be liable, and that's instances where they've gone over and beyond what you agreed in your agreement or in your contract. They can be found liable, but it is always in your best interest, if you're a controller, to have something written down to ensure that you absolve yourself from liability. Then we have the data protection officer. Many of us in this platform are maybe being fronted to become the custodians of data protection in your organization, to become the champion, to be added a duty to ensure that you handle personal data with the care and due regard that it has been accorded to in the Act. And that's where the data protection officer comes in. So the Act has been silent on the skill set that is needed. However, the duties are well enumerated in the Act. The data protection officer may be a staff member, may be somebody who has been added on the duty to ensure that data protection is afforded its due regard, and they may be they need to have skills that allow them to understand matters of privacy, data protection. One of the key recommendations is they can be at least cyber security smart, so that to this cyber security and data protection are so much linked. Somebody who is able to follow through with compliance. They need to give out their details to the Office of the Data Commissioner, because they will be the go-to person. They will be your liaison between you and the Office of the Data Commissioner. They will be that person who ensures capacity building for the staff on your operations with regards to data protection. They will ensure that you've complied with the data protection law. They'll ensure that they will make sure to advise the organization on best practices with regards to data protection. They'll provide advice on the data protection impact assessment. They will cooperate with the data commissioner on matters data protection. So all that is something key for the data protection officer. I wish to end there so that I can take your reactions, your feedback, your questions, as we seek to touch on some of these questions that I was asked to answer. Any reaction, any comments, any feedback, please? Nathan, over to you. You can help moderate the session.
Thank you so much. I had stepped out. I think you are doing the questions now. There is already one question from Timothy on the chat. I would ask us to also post our questions on the chat so that we can get to see the questions and plan.
Okay, Timothy, you can go ahead because I'm using my phone. The advantage of just a small, I'm not able to navigate as I would simply navigate on a larger device. So just go ahead and ask.
The question is, let me read it. Should the confidentiality of a vulnerable person's data be prioritized over the consideration, such as the exercise of their rights? Should the confidentiality of a vulnerable person's data be prioritized over other considerations, such as the exercise of their rights?
Sorry, my network dropped for some minutes there. Kindly go ahead.
Okay, let me read again.
Yes.
You can hear me?
Yes, I can.
Okay, Timothy Koskei asked, should the confidentiality of a vulnerable person's data be prioritized over other considerations, such as the exercise of their rights?
Okay, thank you. I'll answer that. One of the key things you realize about this act is that it's very data subject centric. Okay, it's, you know, all laws that are human rights centric, they tend to lean, you know, the first point of consideration will be the data subject or the subject of the act. So this, in this case, children, you will have to give them much consideration when it comes to how you enforce their rights. But that does not mean that these other people who are not vulnerable per se, that you do not need to accord them the same consideration. The Act has only specified and has been clear that for when it comes to children, you'll have to always check the best interest of the child. And there are other sections in the Act which guide and direct data controllers and data processors on what to do, on step by step, what to do to ensure that the child has been well considered when their rights are being, when it comes to how you deal with their personal data. I hope that answers.
Okay, thank you.
Okay, I can see a hand.
Paris?
My question is, you are at an age where content creation has become a very good or major source of income, and you are seeing cases where these content creators are putting a lot of personal information about their minors out there a lot. Some information might be considered like maybe too much, or just I feel like the rights of these children are being violated. They're being used as a means to make money. I feel like maybe later when they become adults, they might feel like they were violated. When a person becomes an adult, can you still, or what actions can you take against the people who violated you, or against your parent who gave the consent, and you feel like it's not something you'd have wanted for yourself if you were to make that decision then?
Okay, thank you so much, Paris. This is an area that is very progressive, and not many jurisdictions have been able to regulate this kind of space. And unfortunately or fortunately for in the data protection law, it has completely divorced itself from dealing with things that we will call domestic affairs, such that if you're doing something purely on a personal or household or domestic basis, which includes how you post yourself or your family, it has left that from the from the scope of the law, because if it delved into such, it would open up so much that I don't think as at the inception the country was ready to start doing that. And I don't know any jurisdiction at the moment. I will have to research further who have tried to delve into that. But if you post your child, it's usually now in a space of up to you, because you remain the guardian, you remain the one who gives consent. And upon the child turning the age of majority, I don't think they're able to sue, because again it will be taken as something which was outside the scope of data protection. Like, it doesn't delve into domestic affairs. For example, a husband and a wife, you trying to say that you accessed my data on my phone. The Data Protection Act will not try to enforce the privacy of your spouse in relation to you, because that falls outside the exemption. That falls within the exemption of what data protection can aid you. That I want to tie that with the question I have here of again, these influencers, the people who are posting, bloggers, influencers, they post a lot of things, and in relation to the privacy of people. We know, some of us know the tea master, Edgar Obare. He gets a scandal of viewers and it's all over the papers. Or somebody, the question here was about somebody who come up with parody accounts or pseudo accounts. You put a picture there, your Raila Odinga, but of course it's not Raila Odinga, but the name, the picture, So what do you do in such? How does the Data Protection Act treat such? Now, what I can say about this is there are rules with respect to journalism and how the media carry out their work. So that will be left to complement the data, to complement the Data Protection Act. So there are rules on how you should release information, the right of the public to know, all those considerations. However, for anybody who puts up information out there by your own self, maybe you post something and a company picks it up and they start using it. Sometimes it may be taken as though you publicly avail the information, so it's for the general public, so somebody can use it. It's a murky area yet. It has not yet gained traction on how to implement and enforce such things. but you can find comfort in many other regulation, like the computer misuse. I'm sure it has something about impersonation. You know, if you take somebody's, acquire the identity of somebody else, what violation have you committed? So you can find some redress in those other regulation. However, the Data Protection Act has left some of those things to considerations, which are yet to find grounding on how the data commissioner will enforce. And I've seen a question about the WorldCoin saga. Yes, it's something that is ongoing. Somebody has asked, what is the government doing, or what has the government done about that? One of the things the government did was to stop the collection of the data from they stopped the company from further collecting that data. And there's been investigations, and there are committees have been set up to look into the matter, to look into why a company came into Kenya unknown, because the CS for the Cabinet Secretary for Information for Communication is saying he wasn't aware. The Data Commissioner has also said they informed the public not to give their information, but all that is something that is yet to be determined. However, we are being called upon, at least it has awakened our vigilance when it comes to how we allow, or how are the laws ready enough to curb such things and to be able to protect. And we've also seen that we need a lot of cooperation between government, because the CS is saying it is CMA is saying it is ODPC is saying it's not me. There's this back and forth, and we need to come to a realization, okay, who is supposed to regulate this space? So it has opened up such conversations, and we hope going forward we'll be able to be more vigilant on the collection of personal data of Kenyans. I hope that helps to answer what you asked, Paris.
Yes, it does. Thank you.
So I want to go. There are quite a number of questions on the chat. So we will. I will read each, and then I will give Brenda a minute to respond. We have Ezekiel Chepto who asked, can person in records management office be called data controller when handling personal records and customer profile? Yeah, that's the question.
Okay. So I go ahead?
Yes.
Okay. Now, when it comes to a controller and a processor, I know that confuses a lot of times when you ask yourself, we are in finance, I'm in HR, I'm in records. Am I a controller? Then the person in HR is processing. No. An organization is looked at as either a controller or a processor. Whenever you share details between yourself, maybe records, and you share with another department, it is taken as the same organization. It is taken as one. It's not, you cannot say that you in records, you are a controller, and maybe somebody else in another space is a processor, or you in records are a processor. So you're always looked at as one entity. So whatever you do with that data, even though you're in records, you're not taken to be as a one-man show that you are the controller, and then the rest of us, yet in the same organization, are, each of us is a controller or a processor in our own right. No, if you are CMA and you're a controller or a processor, it is CMA. It's not that records or finance or HR or IT. Does that answer your question?
Yes.
Okay.
Okay. Eunice Eunice, are you able to read your question out? Or I can, let me read. Eunice asks, healthcare workers sometimes analyze patients' data, make presentations in conferences, and even publish. Is that illegal considering we ask for consent?
Okay, now one of the things you'll realize that there are certain practices which we have from time to time on how we carry out our duties, and that's why the ODPC has been going around doing public participation and doing what they are calling guidance notes, just to guide different sectors on how to deal with personal data, because we all received the act. However, its application is going to be very different from the financial sector, from the health. There are things we are doing in the health sector which are required. We are required to analyze maybe a diagnosis. I give my notes, and if in any way, always ask yourself the 8 principles of data protection. Whatever you're doing with somebody's data, have I minimized? Have I collected only what I need? While I'm publishing this data of a patient, have I accorded them the utmost privacy? Have I published their names, or can I simply say X instead of publishing Brenda Gabantu diagnosis, then all this? Is there any harm if I pseudonymize, if I anonymize this data, so that I can accord the data subject the utmost privacy? If I'm not able to answer that, and there's no other way, and it's required under written law, then go ahead. But if there are ways you can see on how to accord, looking at the best interest of the data subject, because at the end of the day, you will always be challenged. And once you're challenged, you have to present justification on why you did a certain act. So if you're not able to clearly justify why the data subject felt that their rights were violated, then you will have violated the Data Protection Act. But if there's a justification, then look for ways to accord the data subject the utmost privacy. Maybe you can, it's only published in a closed group, or in a closed, it doesn't have to be on notice board. You just need to look for innovative ways to ensure that at the end of the day, the data subject will always feel they were accorded privacy.
Okay, thank you. I want to read 3 questions here because of time. So I hope you can note them. Let me read some questions, and then you can note all of them, so that you give a common response. Some of them may be. One from John Kanyi says, does the right to access to information mean that educational institutions are wrong withhold transcripts, certificates for fees, balances? Since that is the right, since the right is absolute. The second one from Christine says, considering that subjects have right to their data free of charge, what should one do when such fee is imposed? And is there any exemption? Is there a maximum fee limit? The other question, I want to go one from Eunice again. In HIV on-track tracing, here is something called partner notification, whereby a HIV positive individual gives contacts of their sexual partner. The partners are then contacted to go for HIV testing. Is that legal? And then I want to read the last one, not the last one, the second last from Paris. Says that in relation to minor consents, is it okay for school to post pupils' images and their social on their social media pages without parental consent? I'm tempted to also talk about the people who universities posting grades of those who get receipts publicly. And then from Okech, how do ODPP, police compliance by online survey? Okay, let me do that again. How do ODPP, police compliance by online surveys, compliance with conformity via DPIA requires these surveys correct massive data? I think I don't know if you may need to get clarification from Okech, but those are the questions. You can go right ahead. Brenda, over to you.
Okay, let me start with the easiest. Posting of children's pictures by schools is a violation if they do not get the consent of the parents. So they need to find a way whether to get the consent when they enter school, or maybe through diaries, through the WhatsApp groups, but ensure you have consent. Okay, then I've told you one of the protected groups under data protection is children. So it would be a violation if you went ahead to do anything without the consent of the parents. Look for ways. Do you need parents to sign a code of conduct at the very beginning when the child is entering school? So be it. Do you need to share your privacy policy and parents agree? So be it. But ensure that you can always stand and say, we got your consent to do this. There is the question about withholding receipts. I think that was the first one. The first question, Nathan.
Yes.
Yeah. Just come again. What was the question?
We had from right to access information. It was from John Kanye. Does the right to access to information mean that education is not wrong to withhold transcripts and certificates for fee balances?
Oh, okay. Education institutions, so long as it's not a violation of your privacy, it's not a violation. Unless they are doing it in a way that is outrightly violating your privacy, if they are doing it within the confines of their guidelines, their principles, then they can go ahead. But if they are doing it maybe violating the privacy, for example, those who are posting grades, there's that question about posting grades. If it's in any way exposing other people in a way that they feel their privacy is violated, then they need to look for another way of how to post the grades, or they need to have a sit down with the data subjects and get their consent to carry on with that practice. So I believe the best way is just ensure you get the consent, especially if it's not a practice which is within your law. A good example of a practice which is within the law is how we get insurance. It is within the law for your employer to require you to share details of your next of kin so that they can offer you and them insurance. So that's a practice which you cannot come and say that you're violating my privacy by asking me all these questions. All the employer needs to do is to ensure that once I get those details, I'm not also exposing them to platforms that are not supposed to be exposed to. That's how I can look at it. Then there's the question about the HIV. if it's within the practice that's what should happen for betterment of protecting, looking at the bigger picture and the rights of other people, then they can go ahead. However, again, they should always do it within the principle of they've sought consent, they informed the data subject. All those principles should come into play. How much are they revealing? How much should they reveal? I can have all this information, but I can just maybe share just one set of information. For example, I might be in HR. I want to see if somebody was paid out maybe a medical claim. I don't need to share all the details, their marital status, their appraisals, I only share with you maybe the name, or I share with you the PF number and say, get me the details of how much this person was paid. You see, I've minimized the data that I'm collecting. So also that I can't outrightly say it's a violation or it's not a violation. Always look at the principles of data subject, weigh whatever circumstance you have before you on a balance of the different things you talked about in Unit 1, the principles of data protection, and the utmost interest of the data subject, or is there an obligation legally? All those things need to play out when you're asking yourself of if something is right or not right under the data protection law. There is a question which was just on my mind, but it has skipped me. Oh, about the fees. Now, the regulations were very clear that all the rights are free of charge, except the right to data portability. So if there's anyone charging, you will have to have a good explanation or a justification why you're charging for a data subject to access their rights, and that explanation had better, not lead you to be in compliance with the regulations and the acts. So all the acts are free unless you're able to clearly justify. So I'm telling you that justification is not in the law that if you're not able to enforce the rights of a data subject, justify. The act has simply said all rights are free. Sorry, can you hear me? Hello? Can you hear me?
You keep on breaking.
Okay.
We lost a minute, yeah.
Okay, sorry. I was trying to connect my device to something else, but let me just revert back. Yeah, so I was saying all the rights are free except the data portability. And there's no the act has not prescribed any minimum or maximum. It has just prescribed a reasonable fee. Yes. That's what I can say about that. I hope, was I being heard or I had dropped off again?
Yeah, we heard you.
Okay.
Is there any question that has not been answered? Because our time is really gone, I want to hear, is any question that has not been answered, you can raise up your hand. We can allow you to speak it out. Okay. Now, thank you so much, Brenda, for this session. That was quite engaging. We've learned a lot. I want to request John Kanye, are you able to give a vote of thanks to our facilitator?
Yes, I can. Can you hear me?
Yes, we can hear you.
Okay, I just want to thank our facilitator for the time that she has taken to take us through this webinar. I think we have learned a lot, and it has helped us to brush areas that we could not understand during the videos or the reading the notes. So this was helpful. And on behalf of all my classmates in this cohort, I just want to thank you for your time, and we pray that God blesses you for you.
Thank you. Thank you so much. And thank you so much, Brenda. I don't know whether Vera is able to make a comment.
Hello. No, I just want to extend gratitude to Brenda for taking us through that session very beautifully, and also just explaining all the concepts much better. So thank you very much, Brenda, and thank you, participants, for being with us this afternoon. I want to wish you a very good weekend. Continue with your work. Don't rest too much, and then we can meet again next week. Thank you.
Thank you so much. Before we go, I want to maybe last week on Tuesday, some teams had not met. It's good for us to be comfortable that work is happening. So can we get a comment from team 1?
Thank you, Karanja. This is team 1. Team 1, we've made progress. We have divided ourselves into team A and team B, 2 subgroups to handle question 1 and 2. And we shall be having a virtual meeting, the entire team, on Sunday to review what we've done and then start working on the presentations that we'll be submitting on next Friday.
Okay, thank you so much. Team 2.
Yes, team 2, we did meet. We actually even came up with a name. We are calling ourselves data protection champions or data champions. And we came up with a way of working around the assignments that were accorded to each team. So far, we've managed to give our views, as we didn't what's it called? We didn't form extra groups. We decided that everybody's input is important. So everybody has given their views, and the compilation is taking place. We'll have another meeting on Monday.
Thank you so much. Mikhail, you have a comment? Team 1?
Yes, I do. I noticed that I didn't say our name. We also came up with a name, and it is 108 plus.
Okay.
Yes. So
okay, thank you so much. Let's hear from team 3. Team 3.
I don't know whether Esther is in the meeting.
I think Esther dropped. I saw a text that I think, yeah.
Okay, we have met now. We've met twice. We already started working on the questions, and we have already started working on our presentation. I think we have covered half of the questions, and that is already now in PowerPoint. What we did is we compiled, or whatever, everyone gave their feedback, and from that we compiled something, and now we already have a PowerPoint, and I think we are halfway done. On Monday, we have another meeting before our webinar. We are going to submit the rest of the answers, and then we are going to compile that, and then meet again finally for one final meeting where we are going to just see how the presentation is and decide who is going to present what. So that is our progress so far. That is team 3.
Thank you so much. Team 3 doing very well. Team 4.
Thank you, Mr. Karanja. Hello.
Yes, hi, we can hear you, Dixon.
Thank you, Mr. Karanja. Team 4, we met, and we have our name, Rende. In fact, we decided to pick a Kiswahili name. We are Watawala Wandata. That is our name. And we have divided ourselves in 2 groups, whereby each and every group has got its own responsibility in terms of answering the questions of the assignment of the group. And we are in the progress of doing assignment 1. And I think because we've been given time, we're also going to handle assignment 2 up to where we are now. That is assignment 4. And we have our team leaders as me, Dixon Kinyua, and our secretary is Mr. Theuri Goge. And all members were in a meeting yesterday. In fact, we had a virtual meeting yesterday, and we deliberated on several issues that we are going to present on Friday given time, or Tuesday if time will be available to us. Thank you so much.
Okay, thank you. Thank you. Thank you so much. Team 5.
Thank you, Nathan. I'll give a feedback on behalf of our leader, Elizabeth Itotia. So we met as a group, and we subdivide. The name of our team is Fifth Mile. We already met and subdivided ourselves into 3 subgroups because we have 3 case studies to go through. So the 3 groups are already going through the cases individually, and compiling will be going on through the weekend.
Thank you. Thank you. I think the teams are now all up and running. We have our presentation next week on Friday. And that tells us that as we go for this weekend, it might be our last weekend. It's a 2 weeks program. And therefore, I want to request us to make sure that we achieve quite a lot over the weekend, so that by Friday, we have done all our 3 components, our webinars, we've done them, we've done our teamwork, and we've also done our safari. On the safari, I want to really encourage us to keep track with the milestones. In case you have a problem, most of those in the red zone, I've been reaching out to everyone today, because those in the red zone, I realize that a number of you are stuck a little bit, and because we don't have much time, I want to request that you reach to me. I will also be reaching to you, so that we can plan and make sure that any issues, any challenges are dealt with. And you can also engage your colleagues. Let's work together as a team and make sure that we are moving in this safari. I think we are here to assist and support each other through this safari, especially for those who are about 6 who are still below 10%. That's a red flag. We need to ensure that at least we move towards the yellow zone. Now the milestone change, we have been doing 53%. Now we are now doing 77%. The target for Tuesday is 77%. And now the red zone now starts from 52% and below. That means that if you are 52% and below, now you'll be in the red zone now as we move toward this new milestone. On Thursday, remember, we have a target of 98%. And then on Friday, we have a target of 100%. So let us keep focus on this safari. Let us work together to make sure that we all graduate. Unless you have 100% on the safari, it will be very difficult. It will not be possible to graduate. And therefore, it's good for us to make sure that we've put all our efforts to work in the safari until we have completed at 100%. Any question? any question, you can raise it here. You can raise it on WhatsApp. You can send me a message. We can always engage and make sure that we unlock any issue that is preventing us from progressing. I've shared a link on WhatsApp. Kindly give us feedback. I realize that a number of us are not giving feedback. Kindly make sure that you just give feedback about the webinar. It's good always to have feedback, especially about the webinar, so that we know how to better improve the webinar. So I want to request us to go in and respond to the questionnaire. So I want us to come to the end. I don't know whether there is any comment, anything. And I think with that, we can request Elizabeth Musendi. Can you pray as we end our class?
Yes, let us pray. Heavenly Father, we come before this evening with thanksgiving in our hearts, thanking you for a wonderful session that we had, Heavenly Father. Father, as we go into our weekends and our different ways, dear Lord, Heavenly Father, may you bless us, may you give us, may you protect us, and you give us journey mercies for those who are traveling. We do pray in Jesus' name. Amen.
Amen, amen. Thank you so much and have a very blessed weekend.